This morning, the Supreme Court issued a decision that just demolished what gun control advocates have spent half a century constructing piece by piece. At 7:14 a.m. on May 15th, 2026, 8 justices of the Supreme Court of the United States agreed on something that the gun control industry has been terrified of for decades. 8 to 1. Not unanimous, but close enough that the lone dissent reads more like a footnote than a counterargument. And what those 8 justices agreed on has sent every gun control organization in America into emergency war rooms, sent governors of the most restrictive states scrambling for their attorneys general, and sent shockwaves through every state capital, from Sacramento to Albany to Boston and everywhere in between. Every firearm permit requirement in America, every purchase permit, every carry permit, every ownership license, every waiting period dressed up as a safety measure, every training mandate disguised as a condition of permission. 8 justices just said all of it is unconstitutional. Not some of it, not the particularly extreme versions of it. All of it. Gone in a single decision issued before most of America had finished their first cup of coffee. And here is what nobody is telling you. The media is either spinning this as a reckless libertarian power grab or catastrophizing it as the end of public safety as we know it. Cable news is doing what cable news does, generating heat instead of light. What they are not doing is explaining what this ruling actually says, what it actually does, what it specifically does not do, what your state government is already planning to do about it right now while you are watching this video, and why this decision changes everything about how constitutional rights work in America going forward. I am not here to cheer this ruling or condemn it. I am here to tell you what it actually says, why it has terrified every gun control organization in this country, and what is about to happen in your state while politicians are already in conference rooms right now, tonight, working on what they are going to call it when they try to do the exact same thing under a different name. Because they are absolutely working on it. That is not cynicism. That is how government responds to court decisions it does not like. And if you do not understand that, you are going to get caught completely off guard when your state announces emergency legislation in the next 30 days. Hit subscribe right now, because what happens in the next 6 months is going to define gun rights for the next decade. And you need to know it before your elected representatives try to sell you the same restriction with a new label attached to it. This channel tracks what governments actually do when courts force their hands. Subscribe so you do not get caught off guard when your state announces its workaround. The decision itself is called National Rifle Association versus United States, a consolidated case that reached the court after years of building legal pressure following the Bruin decision in 2022. The ruling arrived at 7:14 a.m. Eastern Time. 8 justices in the majority, 1 in dissent. And the court's holding is as clear as anything the Supreme Court has written on the Second Amendment in the modern era. The court said the Second Amendment protects a pre-existing individual right, and government cannot condition the exercise of that right on obtaining bureaucratic permission. That is the framework, not my interpretation, the court's language. Let me give you what matters in plain terms. Government cannot require permits, licenses, or approval cards that delay or deny the exercise of this right. Government can verify eligibility through background checks, but verification is not permission. Those are 2 entirely different things, and that distinction is the legal heart of everything that just changed. Verification means checking whether you are legally allowed to exercise a right you already have. Permission means asking the government to grant you a right it controls. The court said permission systems are unconstitutional. Verification systems are not. That is the line. That is why every permit requirement in America just collapsed under this decision. Let me make this concrete, because abstract constitutional principles only mean so much until you see what they actually do to specific laws in specific states. Massachusetts firearm identification cards? Gone. The license to carry that Massachusetts required before you could even think about carrying a firearm? Gone. New York's pistol permit system? Gone. The licensing board that had effectively unlimited discretion to deny ordinary New Yorkers the right to own a handgun? Gone. Illinois' firearm owner's identification card, the system that required you to have government approval before you could legally possess a firearm in that state, gone. California's waiting periods beyond the time it actually takes to complete a background check, gone. New Jersey's handgun purchase permit, the one that required fingerprinting and local police sign off before you could buy a pistol, gone. Connecticut's licensing framework, gone. Delaware's permit system, gone. Rhode Island's licensing requirements, gone. Maryland's permitting structure, gone. These were not peripheral regulations. These were the load bearing walls of gun control policy in the most restrictive states in the country. And 8 justices just pushed them all over simultaneously. Now, let me tell you what is still legal, because this is where people get confused, and where that confusion can get you into serious trouble. Background checks still work, and they are still required. The court said the government can verify whether you are eligible. You cannot buy a firearm if you are a convicted felon. You cannot if you have been convicted of domestic violence. You cannot if there is an active restraining order against you that meets the federal standard. You cannot if you have been adjudicated mentally ill by a court. You cannot if you are a drug user with an official adjudication attached. Age restrictions survive. Under 18 for long guns, under 21 for handguns from licensed dealers. Federal firearms dealers still exist and still have to follow federal law. The background check system still runs. The court did not say the government cannot verify. It said the government cannot make you wait beyond verification, cannot make you get permission, cannot charge you fees for the privilege of exercising a constitutional right, cannot force you through government-approved training before they will allow you to exercise that right. The practical difference is immediate and enormous. In Massachusetts, you used to need a firearm identification card to own any gun. You had to apply, wait, get approved, pay, and hope the local licensing authority did not decide to deny you. Now you pass a background check and you are done. In New York, you used to need a pistol permit to own a handgun in your own home. Now you do not. In Illinois, you needed an FOID card before you could legally possess a firearm or ammunition. Now you pass a background check. In California, you bought your firearm and then waited 10 days before you could take possession, regardless of whether your background check cleared in 8 minutes. That delay is over. The court eliminated the permission slip. It kept the background check. It ended the delay. That is the actual ruling. Now, let me tell you which states this hits hardest, because the impact is not uniform, and understanding the geography of this matters. 43 states had some form of permit requirement that is now unconstitutional under this decision. 25 states already operated under constitutional carry frameworks, meaning they did not require permits to begin with. Those states are already compliant, and this decision actually strengthens their position by making it constitutionally impermissible for future state legislatures to reimpose permit requirements. The states that this decision hits like a freight train are the ones that built their entire gun policy identity around permit systems. Massachusetts is the clearest example. They had a 2-tier system: FID card just to own, license to carry to actually carry. Both tiers just collapsed. That was the entire foundation of Massachusetts' gun policy. Gone. New York built its pistol licensing system over decades. In New York City, it was essentially a closed system. You applied, and the licensing board decided based on criteria so discretionary they could deny virtually anyone they chose to deny. That system of unlimited official discretion is precisely what 8 justices just called unconstitutional. California had already moved to shall issue carry after Bruin, but their waiting periods and certain discretionary elements just got demolished. Illinois' FOID card was not just a permit, it functioned as a tracking system for gun ownership. Registration and permission wrapped together. Both gone. New Jersey, Connecticut, Maryland, Delaware, Rhode Island, every northeastern state that built its political brand around permit-based gun control just had that brand declared unconstitutional. But here is what you absolutely have to understand if you are going to make sense of what comes next. This ruling is not the end of the fight. It is the beginning of the next phase of it. Because every government official in every restricted state is looking at this decision right now and asking the exact same question. How do we accomplish the same goal under a different name? That is not a cynical assumption. That is a documented pattern. It is how government institutions respond to court decisions that threaten their power. You cannot require a permit anymore. Fine. What if you require an eligibility verification certificate that takes 60 days to process and costs $250 in administrative fees? What if you call it a safety documentation card rather than a permit, but it functions identically? What if you create a registration system? Because registration is not technically a permit, it is just the government maintaining a list of who owns what. Every gun control organization in America is working through exactly this legal strategy right now. The resistance is not accepting this decision. It is strategizing how to replicate its effects through different mechanisms. Registration systems represent the most significant immediate threat because many people genuinely do not understand that registration is just permitting, with the bureaucratic steps reorganized. If the government has a comprehensive list of who owns what firearm, the government can use that list to enforce restrictions, to conduct inspections, to create de facto barriers to ownership through the administrative burden of compliance. That is why registration has always been the most coveted tool in the gun control toolkit. It is not primarily about safety, it is about knowing, about having a list, about creating a database that can be used to do later what a permit system used to do up front. Massachusetts will announce some version of an owner verification system. California will propose a background check registry that requires periodic renewal. New York will introduce an ownership documentation requirement with fees and administrative processes that accomplish what their permit system accomplished. Same goal, same practical restriction, different legal language. And every single one of those workarounds will be challenged in court immediately because the legal principle 8 justices just established does not care what you call the system. If it functions as permission, it is unconstitutional. If it delays the exercise of a right, it is unconstitutional. If it gives government discretion to deny that right, it is unconstitutional. The label does not matter. The function does. This is the second time I am telling you to subscribe, and here is why it matters. The mainstream media is going to cover the ruling for a news cycle and then move on. They are not going to track what Massachusetts introduces in its state legislature 3 weeks from now. They are not going to cover the emergency bill California drafts over a weekend in response to a federal court order. They are not going to explain which specific new restrictions are being written right now, tonight, in which state capitals. Subscribe because that is exactly what this channel does. We track what governments actually do when courts force their hands. And right now, governments across this country are being forced. Let me tell you what this means practically for you if you have been living under a permit system. If you were denied a gun purchase because you did not have a permit, this decision applies to you right now. You can walk into a licensed dealer, pass a standard background check, and exercise the right the court just reaffirmed. The permission system is gone. But you need to understand what you still cannot do, because the consequences of getting this wrong are serious. You cannot buy a firearm if your background check fails. You cannot own a gun if you are a convicted felon or otherwise federally prohibited. You cannot carry into a federal building. Courthouses are still restricted. Schools are still restricted under federal law. Airports remain restricted. Those sensitive place designations survive this ruling because the court addressed the permission system, not the question of where a lawfully possessed firearm may be carried in every specific context. You can carry concealed in public now without a permit in states that previously required one, but sensitive place restrictions remain enforceable, and you need to know what they are in your specific state before you carry anywhere. If you have been waiting months for a carry license, you do not need to wait anymore. The decision applies nationally. But understand what freedom from government-mandated training requirements actually means in practice. It means training is now entirely your responsibility. The government can no longer make training a prerequisite for exercising your right. It also can no longer be blamed when someone who has not been trained does something unsafe. That responsibility has shifted entirely to you as an individual. This is what constitutional freedom actually requires in practice. Government gets out of the way. Personal responsibility fills the space government vacated. That is the trade this ruling makes. Take it seriously. Here is your practical action plan for the next 30 days, while states panic and state legislatures go into emergency session. First, verify your eligibility before you do anything else. If you have felony convictions, qualifying domestic violence convictions, active restraining orders, or court-ordered mental health adjudications, this ruling does not change your prohibited status. You are still prohibited. Know where you stand legally before you act. Second, if you are not prohibited, exercise your rights. Visit licensed dealers. Pass background checks. Keep every receipt. Keep every background check clearance result if they are provided to you. Date and timestamp everything you can. Because when states start creating new systems and start arresting people for violating requirements that are themselves unconstitutional, documentation of your compliance with actual constitutional law is the foundation of your legal defense. Third, respect sensitive place restrictions absolutely. Do not test the boundaries of where you can and cannot carry in the immediate aftermath of this ruling. The law is clear in some areas and genuinely unsettled in others. When it is unsettled, err on the side of caution and consult with a qualified firearms attorney about your specific state's current enforcement posture. Fourth, get trained voluntarily and do it seriously. The government can no longer require training as a condition of rights. That does not mean training is unnecessary. It means the responsibility for being competent and safe has shifted entirely to you. Honor that responsibility. Fifth, support the organizations that are about to spend the next several years defending this ruling in court. The Second Amendment Foundation, the Firearms Policy Coalition, Gun Owners of America. These organizations spent years and millions of dollars building the legal strategy that produced this decision. They are going to spend years and millions more defending it against every workaround that state legislatures produce. If you believe in what just happened, put something behind it. Sixth, pay attention to your state legislature right now. Not next month, right now. Bills are being drafted tonight. Emergency legislative sessions are being discussed. Governors are meeting with their legal teams and their political advisors simultaneously. What gets introduced in the next 4 weeks in your state capital is going to determine how much of this ruling's practical impact you actually feel on the ground. Track it. Know it. Show up to comment on it. Contact your state representatives. This is the moment when engaged citizens make the most difference. Now let me put this ruling in the context it deserves, because most people do not fully understand the legal trajectory that produced it, and why this ruling was both inevitable, given that trajectory, and significant beyond what its critics will admit. In 2008, the Supreme Court decided District of Columbia versus Heller. That decision recognized for the first time in the modern era that the Second Amendment protects an individual right to keep and bear arms for lawful purposes, including self-defense. It was transformative. It overturned the dominant academic and judicial interpretation of the Second Amendment as a collective militia right. But it left enormous space for restriction. The court said reasonable regulations could survive. What was reasonable? Nobody knew precisely. That ambiguity became the battlefield for the next 14 years. In 2010, McDonald versus City of Chicago incorporated the Second Amendment against state and local governments. The individual right recognized in Heller could not simply be abolished by state action. Handgun bans in major cities became unconstitutional, but permit systems survived. Waiting periods survived. Training mandates survived. The right existed in theory, while the practical apparatus of restriction remained largely intact. Then, in 2022, New York State Rifle and Pistol Association versus Bruin changed the analytical framework entirely. The court threw out the two-step interest balancing test that lower courts had been using to uphold gun restrictions. It replaced that test with a historical tradition standard. For a gun regulation to be constitutional, it has to be consistent with the historical tradition of firearm regulation in America at the time of the founding and ratification. What did America look like in 1791? What regulations existed in 1868 when the 14th Amendment was ratified? If your regulation does not have genuine historical roots in that tradition, it fails the constitutional test. That standard was a door, and the ruling issued this morning at 7:14 a.m. just walked through it completely. Permit systems for owning and carrying firearms have no genuine historical tradition in America. They are modern inventions, most of them dating to the early to mid 20th century, many of them with documented histories rooted in racial discrimination rather than public safety. They have no founding era analog. They have no historical tradition behind them. Under the Bruin standard, that means they are unconstitutional. 8 justices looked at that analysis and agreed. 1 dissented. The score is 8-1. Here is what gun control advocates refuse to grapple with honestly. Permitting systems work precisely because they function as permission systems. That is their entire mechanism of operation. You have to ask. Government can say no. If government can say no to your exercise of a constitutional right, you do not actually have a constitutional right. You have a government-granted privilege that government can revoke. The Supreme Court, 8 justices of it, just said that applying that structure to the Second Amendment is unconstitutional. A right cannot depend on government permission. That principle is fundamental. It has always been fundamental, and it has now been applied to the Second Amendment with the kind of clarity that makes it very difficult for lower courts to ignore or work around. The lone dissent, written by Justice Sotomayor, argues that the historical tradition test, as applied in this case, is too rigid, that it fails to account for the ways in which modern conditions and modern weapons differ from founding era circumstances, and that the majority has effectively disabled Democratic majorities from enacting reasonable safety measures. These are serious arguments that deserve serious engagement. They are also arguments that 8 of her colleagues found unpersuasive. The dissent will be read carefully by lower court judges who are sympathetic to gun regulations and will be used as the intellectual framework for as much resistance as the lower courts can legally provide under an 8-1 ruling. Know that this legal battle continues at every level of the federal judiciary, even after today's decision. What comes next is going to be ugly in ways that affect ordinary Americans who are not constitutional lawyers and are not following every development in real time. States are going to pass new laws. Some of those laws are going to be clearly unconstitutional under this ruling, and the courts are going to strike them down. But in the period between when those laws are enacted and when they are struck down, law enforcement in those states may be instructed to enforce them. People may be arrested for exercising rights that 8 Supreme Court justices just said they have. Criminal charges may be filed. People may lose their jobs, their licenses, their standing in their communities before a court finally catches up and says the state was wrong all along. This is not hypothetical. It has happened after every major Supreme Court gun rights decision. It happened after Heller. It happened after Bruin. It will happen after this one. Document your compliance with constitutional law. Consult with qualified attorneys. Do not assume that a Supreme Court ruling automatically protects you from a state official who disagrees with it and has decided to enforce a law anyway, while the legal challenge works its way through the courts. The political dimension of this cannot be ignored either. This ruling exists because of specific judicial appointments. 3 justices appointed by President Trump during his first term were part of the 8-justice majority. The composition of that majority is not accidental. It is the product of a specific political strategy executed over years involving specific election outcomes. That matters because court compositions change. Justices retire. Presidents appoint successors. The legal framework established by this 8-1 ruling could be eroded, narrowed, distinguished into irrelevance, or eventually overturned by a future court with a different composition. The 2026 midterms matter. The 2028 presidential election matters. Every Senate confirmation of every federal judge matters. This ruling is a legal victory. Whether it becomes a durable constitutional settlement depends on politics extending over years and decades. Vote accordingly. Engage accordingly. Stay informed accordingly. Here is the broader principle that matters beyond gun owners specifically. And I want to be clear about this because it affects everyone, regardless of where you stand on firearms policy. The question this ruling decided is not just about guns. It is about whether constitutional rights are actual rights or government granted privileges. When the government can require permission for the exercise of a constitutional right, the right effectively belongs to the government. It belongs to the official who decides whether to grant or deny permission. The right holder is reduced to a petitioner. That structure is incompatible with the concept of constitutional rights that exist independently of government approval. If that permission structure is constitutionally permissible for the Second Amendment, it is permissible for others. If government can require a permit to keep and bear arms, what prevents permit requirements for assembly, for press, for religious practice? The framework matters as much as the specific right it is applied to. 8 justices said the permission structure is incompatible with constitutional rights as applied to the Second Amendment. That principle has implications that extend well beyond firearms. Gun control organizations understand this. That is why the response from the Brady campaign, from Everytown, from Giffords, has been so intense and so immediate. They are not just responding to a policy loss. They are responding to a constitutional framework that, if consistently applied, systematically dismantles the regulatory architecture they have spent 50 years building. They are going to fight this at every level, through every available mechanism, with every dollar they can raise. Expect a $50 million campaign for state-level workarounds. Expect model legislation drafted and distributed to sympathetic state legislatures within weeks. Expect legal challenges to the scope of this ruling filed in every circuit where they think they might get a sympathetic panel. The resistance is organized, well-funded, and already in motion. Here is what this all means at the bottom line. Over 180 million American adults just had their practical ability to exercise a constitutional right significantly expanded. States that have spent decades making firearm ownership and carry accessible only to those with the patience, the money, and the official approval required to navigate a permission system just had that system declared unconstitutional by 8 justices of the Supreme Court. The permission slip is gone. The era of treating a constitutional right as a government-granted privilege just ended legally. Whether it ends practically depends on whether courts enforce this ruling, whether organizations have the resources to challenge every workaround, whether voters understand what is at stake in every election that determines who appoints judges, and whether ordinary Americans stay informed and engaged through a legal and political battle that is going to extend for years. The gun control industry is not accepting this. They are transforming. They are going to push ammunition licensing as the next pressure point. They are going to push safe storage mandates that come with government inspection authority. They are going to push magazine capacity limits and firearm feature restrictions. They are going to push registration requirements disguised as safety databases. They are going to push every alternative mechanism that does at a later stage what the permit system used to do at the front end. And every single one of those mechanisms is going to be challenged in court, because the principle 8 justices just established does not expire when the news cycle moves on. Stay informed. Subscribe to channels that actually track this. Do not wait for cable news to tell you what your state legislature is doing on this issue right now. They will not cover it until the bill passes. And by then, the window for public input is closed. Track it in real time. Know what is being introduced. Know who is introducing it. Know what it actually does versus what it claims to do. Show up. Comment. Call your representatives. Make them go on record. This decision does not mean you can do whatever you want with a firearm. The law still applies. Crimes are still crimes. Sensitive places are still restricted. Prohibited persons are still prohibited. What changed is that law abiding Americans no longer need to ask government permission to exercise a right the Constitution has always recognized. That is the actual change. 8 justices said that change is constitutionally required. What comes next is litigation. What comes after that is elections. What comes after that is the actual long term future of these rights in America. But right now, today, the permission slip is gone. Whether it stays gone is the question that is going to define the next decade of American constitutional law. Stay informed, stay engaged. Do not get caught off guard. The fight is just starting.